your time. We can start the meeting very quickly. Uh, so the, this is a company which provides service for uh, writing patents and giving us some kind of help in publishing these patents. So um, their client list is very big. Their search, I mean, their history there is also very good. And from this IIPRD, we have with us today Mr. Lalit, who is a patent attorney, and he'll be briefing us about the different steps that are followed here by IIPRD to publish the process from the beginning, from where we submit our research to them, patent to them, and till the publishing process, till the granting. I heartily welcome you, Lalit sir, to this session, and I would
Thank
like
you
you
so
to
much,
take
sir.
over and deliver your talk.
Sure, sir. Thank you so much.
Thank
Thank
you.
you. So, first of all, I would like to express my gratitude to Mr. Ellison, Dr. Amit Chauhan, for initiating this session, and I warmly welcome everyone in this session. And I mean, we start with the process of how we start once we receive the ideas from the inventors, how we proceed towards prior art search, and then receiving comments from the inventors, and then drafting the patent application and filing it. So this entire process from the very start to the grant and everything will be covered in this particular session. And post that, as usual, if someone have queries, then definitely we will try to address them, right? So with permission from Mr. Sudha, should I start or we have to wait for others to join also? Dr. Sudha?
Yeah, I think you can start. So anyhow, it's recording. So those who are interested can see the recorded video.
All right, great. Sure. So before we start, I would like to tell you a bit about the patents thing and how patent are granted and what are different benchmarks for getting a patent grant, right? So once a patent, an idea is conceived by an inventor, then to protect his rights, he wants to get a patent so that he can stop others from copying his product or his invention and get a monopoly over his invention or his creation, right? So patent, as you already aware, that these are exclusive right granted to the inventors for their inventions, right? So patents are granted for a limited time period of 20 years from the day it is first filed. The day from the day a patent application is filed, patent rights are given to the inventors for 20 years. Post 20 years, the patent or the invention becomes public, and anyone can use it, right? So what happens when you got an idea and you want to protect it, you file a patent application, right? So patent application is examined by the patent authorities or the patent office. Examination, by examination I mean that the patent office assesses the invention on three parameters or three benchmarks, which are uh, the first one is a novelty, and the second one is inventive step, and the third one is industrial application. So going to the novelty part, what really the patent office examines in this for this criteria is the newness of the invention. So newness, I mean, it is totally logical to grant rights only to the new invention, because if already someone has made something and it is in public domain, then there is no point granting a patent to that inventor who filed a patent application for an already existing invention, right? So you must agree that patent should be given to only those inventions which are novel or new in nature. So first criteria for getting a patent grant is that it should have novelty in it, novelty or newness. Then the second thing is that it should also have inventive step. Inventive step is what you made up, you come up with the idea, but that idea should also be something that it creates an inventive leap from the existing patents or existing invention. Say, for example, if you have invented a pencil, then that pencil should be inventive over the already existing product of this particular kind or this particular nature. So, I mean, the existing pencils and your invention should have inventive leap. Yeah, that means your pencil should have something that advances the technology in the pens in the pencil domain, right? So inventive step is the second criteria which is being used to assess an invention, correct? So what happens when only say for example only the criteria of novelty was there? So novelty can be achieved by adding anything to a existing product. Say for example you have a pen or a pencil and you add something, some anything, I mean anything could be added to make it new and claim that it is a new product. But what happens, the patent office or the patent act or the patent law says that the invention should not only be new, it should also have some inventive feature or inventive step for which a patent should be granted. So inventive step is the criteria that ensures that every patent granted should have some advancement in the technology of that particular domain, right? So second criteria is the inventive step. Then after that comes the third criteria, which is, I mean, this is very vague kind of criteria. I mean, it says that it should have every invention should have an industrial application. So I don't know why it is been there, because every invention has to have some sort of application in an industrial application, right? So third criteria is not that important, or that it doesn't impact any invention or a patent application file, because I mean in almost every case the objection from the patent office is on the first two criteria, that is the novelty and the inventive step. So third criteria we can forget about. We should only focus on these two parameters, the novelty one and the inventive step. So I told you about a bit about novelty as well as inventive step. If you have any queries, you can ask me about these two things. Otherwise, we can move forward to the next step. And I hope I'm clear. I mean, I'm audible to everyone and my voice is clear. There is no lag or any kind of issue from the network side, right? I assume that. If you, in case you feel like, you can raise your hands and let me know that there is some problem. So now moving forward with the next step. So that is why a patentability search, what it is and how we do it, and not how we do it, why should we do it. So what is a patentability search or a novelty search? I mean, so when we talked about the two criteria, first two criteria of getting a patent was the novelty and the inventive step. So to check about the novelty and the inventive step, we have to perform a prior art search or a patentability search or a novelty search or a newness search, whatever you may want to call it, you can call it, but it is in general or in generic way, it is a prior art search. So a prior art search is a search That includes both patents as well as non-patent literature, patent literature plus non-patent literature. So a patentability search or novelty search or a prior art search help us in identifying uh, help us in identification of prior art. The second help that it provides is in the assessment of proposed invention, and the third thing, it helps us in the patent planning process, planning the process for getting a patent. So we first go to the identification, the very criteria, or the first thing that a prior art helps us is in the identification of a prior art. So prior art is nothing but the documents or reference or literature available or in public domain already. So for example, you created an invention and you want to see whether my invention is new or novel or not. Then what you will do, you will go to I mean, you yourself can do it, or you go to a patent agent and ask him to conduct a prior art search. The agent will uh, have access to global patent databases which he use and retrieve patent application. If he's using patent literature database, then he will retrieve patent documents from the database and let you know that these are the closest prior art or literature from patent domain, and this is how it is. I mean, it relates to your invention and it can hamper the chances of getting a patent for your product or your invention, right? So first thing is the identification of prior art. So prior art are of two types. First one is the patent literature search, patent literature, and the second one is non-patent literature. In patent, obviously, it relates to patent. I mean, every patent or a patent application recorded by different or multiple patent offices are given access to to the general public so that they can access it and take advantage or take information from it and uh, take reference from it, and then accordingly maybe they can review those literature and then go into research development in a particular field. Or say for example, in the case of if you have invented something and you want to assess the chances of getting a patent, you can use that literature to assess the chances of getting a patent. So first thing in prior art search is patent literature, and the second thing is non-patent literature. So every patent application or a patent granted patent is a part of patent literature, and everything else, everything, I mean, every article, everything published on web or anything published in a newspaper, for example, or anything, any article in a news magazine or anywhere else, anything published and apart from patents is a part of non-patent literature. So to assess the chances of a patent of an invention, we use these two literatures to assess whether that invention, the proposed invention, the one you are proposing, is new in nature or not. So the first thing a prior search do and help the inventors is in the identification of prior art. I hope you all are clear with the prior art. So when you, the inventors, share your ideas with us to assess the chances, what we do a prior art search. We can call it a patentability search, we can call it a novelty search, or we can call it, I mean, accordingly, we can name it the way you want it, right? So a prior art search is used to assess, to retrieve the patent and non-patent literature, and then accordingly compare the proposed invention with the prior art, and then see whether any new feature is there in the proposed invention, or it has in the inventive step in it based on the comparison between the prior art and the proposed invention features. So the first thing was identification, and the next thing is assessment of proposed invention. So we also partly, I mean, I told you about this partly in my in my first thing, which relates to identification, the assessment of proposed invention. So when you submit your idea to the patent attorney, it will retrieve patent applications or patents or any literature non-patent literature and compare the features or aspects of the proposed invention with the prior art, and then based on that comparison, he will assess the chances of getting a patent for that particular product. So second thing a prior art search does is it helps in assessment of an invention by comparing it with the prior art. The third thing is it that it helps in planning the patent. I mean, once you are done with the prior art search, you know that these kind of already existing things are there in public domain, and these things can hamper my chances of patent. Then you have to plan accordingly, so that I mean, in some cases or in most cases where even after a prior art search, if something comes up which is very close to the invention, then inventors are keen to file patent application, so that in some way they can protect even the slightest chances of getting a patent, right? So uh, the inventors want to see what chances do they have after the prior art search. So these were the three things that we do in prior art searching. So I would also like to elaborate a bit on identification of prior art. So as I already mentioned that in identifying the prior art, what happens, we do search on patent databases and try to retrieve existing published patent application. There is a different, ladies and gentlemen, between the patent and a patent application. So the patent is we can say a patent is granted only when every criteria of patentability is fulfilled and the patent authority has said that it is a patent and it has some sort of claims which are granted in nature. So when you submit your idea to the patent office, you should not say that I have a patent. You should say that I filed a patent application and it is in so and so stage during, and it is in prosecution with the patent office. So in the prior art search, we identify all existing patents as well as published patent application. So there is also a difference between a patent application, filed patent application, and a published patent application. So when you file a patent application, it doesn't publish automatically. It has to wait generically for 18 months to get published and get into public domain. So not every patent application or every filed patent application is accessible to the people, even to us. If you, for example, you file a patent application, then it is not available in public domain till 18 months from the filing date. You can expedite this process, and that is a different thing that I will let you know. I mean, publication happens in two ways: normal way or expedited way. So early publication could also be performed. Say, for example, you wanted to someone to see your patent application, you want to help in getting details of your invention, then you can think about getting it published by filing early publication forms, and then accordingly by early publication every patent application get published within 1 month. Not you don't have to wait for 18 month time period. So non-patent literature, as I told, it relates to article, technical papers, or whatever present on web. Anything published and in public domain is non-patent literature, which is not a patent. I mean, one, we can classify prior art into two parts. One is patent thing, and the second thing is the non-patent thing. The non-patent literature relates to articles, technical papers, etc. So how assessment happens when say for example you got your search report, and how it can help you in assessing the your invention. So assessment relates to, as I mentioned earlier also, the assessment is related to comparing the prior art with your proposed invention. So assessment is based on the disclosure by the prior art, what thing it is disclosing and how it hampers your invention. We can compare those things, and then accordingly we can assess the chances of getting a patent. say for example, when you file a patent application, you can when you I mean you do this prior art search, you can assess the chances of getting a patent by seeing how much amount of information is present in that particular prior art. So for example, it has the gravity or it has the depth which you have in your invention. Maybe the prior art disclose the thing, the invention in a very generic way or in a very higher at a very high level, but you have that kind of information with you which help you identify the gravity between your invention and the prior art. So assessment of gravity of potential of getting rejections from the patent office can also be assessed by the prior art search. So how a prior art search helps in the planning of a patent, getting a patent right from filing a patent application and then into the examination and then prosecution with the patent office and then getting a patent thing done. So what happens when you did this prior art search and you got a report with you, you can see what amount of information and how much information is being present by that. Say for example, if one particular prior art is being discovered in the search, then you can use that information to see how to write the patent application. I mean, I would like to tell you one thing, that when a patent search or prior art search is done and you got the report and it says that so and so prior art is identified and it has the chances of hampering the patent prospects of your invention, then there is to nothing to worry about, in the sense that still you can go through that document, the prior art that is being retrieved by the prior art search, and then you can try to see how much amount of information is there in that particular prior art, and then based on the differences between the invention and the prior art, you can then move ahead and then file a patent application accordingly. So patent this prior art search helps not only in assessment of novelty and inventiveness of a particular invention, it also helps you in strategizing your journey of filing a patent application and getting a patent. And also, obviously, it helps in identifying the right areas to target. So for example, if you have an invention which has one or two aspect number A or aspect number B, then say for example, aspect A is already being disclosed by a prior art, then you can accordingly focus on the second aspect of the invention. So this way, the prior art search helps you in getting a right kind of patent application. So if you, let's assume that you didn't have done a prior art search, then obviously you were not aware of the prior art in that domain, and you file a patent application which focuses on only on one aspect, that is aspect number A, because you were in oblivion of this fact that this thing is already in public domain. So a prior art search can also help in you planning the patent application filing. So one thing was that in planning was a patent application requires you to disclose a statement which is called objective technical problem. So in a patent application or in a patent file, patent specification, when you write a patent application, it needs to have a clear and unambiguous objective technical problem that you are trying to solve in your patent application. So to identify the thing, this objective technical problem, this prior art search will help you in getting the right technical problem you are trying to solve. Right. So this the prior art search also helps you in getting to the right objective technical problem. And accordingly, once you identify the objective technical problem, you are you are in a position to give the statement related to the solution in a more clear, more precise way. Is there a question? All right. So moving on, I mean, a patent application or patent specification should have a clear objective technical problem. You should name it, or you should specifically tell the patent office in your patent application that this is the technical problem I'm trying to solve, and you should also give a very clear thing about the solution you're trying to give in your patent application. So the prior art search also helps you in identifying both the technical problem as well as the solution. All right. So after the patent application planning, I mean, the patent, this prior art search also helps in drafting right kind of independent claims. So I would like to tell you that there are two kind of claims in patents. In a patent, one is independent claim and the second is dependent claim. So independent claims are the broadest claim, or the claims that is going to provide you the protection when you file a patent application and you got a patent. So a patent search, patentability search, or a prior art search also helps you in drafting the right set of independent claims. Independent claims should have precise information about what thing it is disclosing. The statement of independent claim is very, very important. So a patent application, a prior art search helps you in creating a balance between the broadness and the narrowness of a claim or the claim statement. So what happens, patent office perform examination on the independent claims. The matter present in independent claims is taken up by the patent office, and then examination or prior art search is performed by the patent office. The same way we do it here, the patent office also have examiners which examine the patent application based on the prior art. So they also identify prior art from the literature, and then accordingly used it to assess a particular invention. So once a search is done, you will have access to the information, and you can yourself see that up to what level your invention is being disclosed by that particular prior art, and you can use this information to create an independent claim which is right or balanced in terms of broadness and narrowness. So what happens, what is a broadness and narrowness of a claim? So when a claim is written, if you write a very broad claim, then obviously a number of prior art will get infringed or will get affected. So if you write a broad claim, a number of prior art could be cited against your patent or your claim. And if you write a very, very narrow claim, then it also has this one disadvantage that you will get a very narrower protection in your patent application. So it is very, very important to create a balance between the broadness and narrowness of your claims. And by claims, I mean the independent claims. All independent claims should be such that once you are done with the prior art search, you know that what kind of information is there in public domain. You should not write a patent that infringes already existing information. So you will add some information from your application or your invention that makes it different or distinct than the prior art. This way you make it narrower. But it is also advised that you assess that the additional steps or the additional features you are adding into your claims should not be such narrow that it create a very narrow claim and the protection for your invention get totally destroyed. So it is totally and very, very important to create and assess the narrowness and broadness of a patent claim or an independent claim. So this brings us to steps. So you submit your idea and a search is being done by the patent agent or by yourself, and a report is in your hand. What else do you need to do as an inventor? So this query was particularly raised by the team, by the VIT team, and they ask us to tell the inventors, because I mean most of the inventors are perplexed as to what should we do once a prior search is done and we get the report. So let me tell you what you should do once you have the report in your hand. So once you have the report, let me present you one report with you. So this is our standard patentability search report that we share with our inventors. So this way we cite the references. So let's start from very beginning. So we write understanding here, objective of the search, understanding of the subject matter of the invention, and we identify inventive feature that have the potential to make a claim out of it. So these feature one or feature two, these are potential inventive step of this particular patent application. So we have identified 4 feature in this application, in this particular search report, and then we have assessed these 4 features in view of the prior art we have identified. So these all things are related to how we do the search, keyword used, and patent classification used for the search. So searches, when we do searches, we can do searches based on keywords as well as on patent classification. So when we do patent classification based searches, if anything is not covered in through the keywords, it will get covered through the patent classification. These are the databases we use for search. Questel Orbit is a private or paid or subscribed patent database which we use for searching patent literature. And these are the patent as well as non-patent databases which we use to retrieve patent applications and as well as non-patent literature. So when we cite, we have identified for this particular case, we have identified this patent number. So this patent number is titled so and so, and it was published on so and so date. Now we cite the reference or text from this patent application. So this text is very limited, and this text is limited to the 4 feature which I just mentioned. Those 4 features are tried to be covered by presenting this particular text. So this text relate to the 4 feature. We try to map it so that we can say how many of these features are disclosed by the prior art and what is not being disclosed. So this patent number is hyperlinked. We provide hyperlinks in the patent number, in the patent application number or patent number. You can, if you want to see and thoroughly read the patent application, you should click on it and go through the entire document or the entire text of this particular prior art. So this text is not the entire patent, I mean, not the entire text relates to this particular application. This is just a limited text which we have used to map the 4 features we have identified as inventive. So we advise you to go through not only this text, we also advise you to go through the entire document and you yourself try to read it and see whether everything is there in that particular document or not, because we may be under wrong impression that it is disclosing the same thing and accordingly opine that your invention can be objected for lack of novelty or lack of inventive step. But I would advise you to go through the entire document and make your own understanding of the invention of the prior art, and then try to assess it whether it is actually disclosing the same thing or not. So this way we cite a number of prior art references, generally 4 or 5 references, and then try to map it in this table. So this is the summary of table. We have identified, I show you that 4 features, 4 potentially inventive features are there in this particular proposed invention, and what things are disclosed by these prior art references. One, so here we try to map the teachings of the prior art with the proposed invention. So feature number 1 is present in the first reference. This reference number 1 disclose feature number 1, feature number 2, but it is mute on feature number 3 and 4. So I mean, we can say that patent reference number 1 is not totally anticipatory. It is disclosing the information, but not entirely. So this way, patent reference number 2 is also disclosing partial information about the proposed invention. It is also disclosing feature number 1 and feature number 2, and mute about feature number 3 and 4. And when we go to prior art reference number 3, it is disclosing first feature and it is disclosing about fourth feature, but mute on second and third feature. So this way, the fourth reference is also mapped. It only talks about first feature and mute for the rest of the 3 features. So this way we can assess that feature number 3 is not being disclosed by any of the reference, and we can say that it has the potential for getting a patent or getting a protection, because everything else out of these 4 features is being disclosed by one reference or the other, but this feature number 3 is not there in any of the invention, any of the prior art. So this feature number 3 has the potential to get a patent application filed and then accordingly get a patent over it. So likewise, when I mean, in reference to the search this table, we opine here our observation. So we summarize what every prior art is disclosing and what kind of objection can be raised by the patent office. So here we say that if we combine all features 1 and 4, then the patent office can raise so and so kind of objections. And we suggest what could be done when you file a patent application. How should you file a patent application? So this is a typical patent search report or prior art search report we share with the inventors, right? So coming back to the presentation. So when we share this report with you, you are advised to go through each of the reference in detail, not just the text we share with you. You should go through it thoroughly. I mean, every patent or reference is hyperlinked. You should access it, read it in totality. I mean, every paragraph of it, everything present there. Then compare your invention with the prior art reference. The information present in the prior art should be compared with the information you have with you as an inventor. And then maybe you can create your own table and write that my invention had so and so features, and reference number 1 is disclosing this thing, it is not disclosing this thing. You can check mark or make a cross for, I mean, you can create a check mark for everything, anything present in that prior art, and whatever is not present, you can make a cross mark for it. This way you can assess that whether all of the prior art disclose all of the features, or is there any feature which I can use to tell the attorney that this is the feature you should focus on, and you should file a patent application focusing on this particular aspect of the invention. Right. So when we compare our invention with the prior art, it is very important to see that, because what happens when you have an invention in your hand and you want to compare with the prior art, you should easily identify some differences between the prior art, because it is a kind of way to say that everything is exactly present in that particular prior art. So we have to identify only those differences, because differences could be any kind, but we have to identify those differences which are inventive in nature, inventive, as well as non-obvious to a person skilled in this domain. So for example, you are from pharma domain, then if you say that this is the difference between my invention and the prior art, then the person who is also skilled in this domain should not say that this is a kind of obvious improvement and obvious thing you have done. There is no novelty or inventiveness in it. So you should identify the kind of differences that it should showcase that it has inventiveness in it, and it is non-obvious to a person of that particular domain. So only those differences which have the potential of getting a patent protection, for it, it should have inventiveness in it as well as non-obviousness. These are two criteria that I would advise you to keep in your mind when you assess your patent application with the prior art. You should identify those differences which makes it inventive, inventive in the sense that it is giving the it is giving your invention some technical advantage or technical improvement over the prior art, right? So if obviously if you have identified at least one difference which is inventive as well as non obvious to a person skilled in that domain, then you should tell your attorney that this is the thing which is not disclosed by any of the reference single-handedly, or even when we combine all the references, you should focus on this particular application, this particular aspect when you file or draft a patent application. So this is how we should process the patent prior art search report, and then this is the way we should assess the chances of getting a patent for your invention, or whether and to make your mind whether you should go ahead and file a patent application for your invention or not. So this is I mean, this is how we say that this how we assess a patent or prior art search report. And if we talk about the process of getting a patent, what happens when you conceive the idea, you typically perform a search, although search is not a mandatory thing. I mean, you can directly go ahead and file a patent application. No one gonna ask you that why didn't you conducted a prior search. You should, if you have idea and you have a confidence in your invention that this is something novel and inventive, then you can directly go ahead and file a patent application. There is no need or no mandatory thing to get a search done, right? So but search is obviously recommended just to write the patent application in the right areas and targeting the right thing and in the right manner with right balance of independent claim, the narrowness and the broadness thing we talked about. So after searching, obviously when a search report is done, you being the inventor tell us what differences you have identified in the invention and the prior art we have shared, and then based on those references we draft a patent application. Drafting relates to creating a patent application. A thorough patent application includes the title, the summary, the claims, the detailed description, the brief description of drawings, and elaboration on the different drawings being used. So the sole objective of a elaborate patent application or a comprehensive patent application is that the Patent Act says that a patent application should be something. It should be written in such a way that anyone from I mean a person skilled in that domain can can uh, can ex can make a I mean it can experience the same thing. I mean you want to whatever you want to express in the patent application should be clearly and concisely what expressed in your patent application, and anyone of that domain can experience it, and accordingly if he want to make any amendments or any improvement to that idea, he can do so. right? So there are clear instructions from the patent office that every patent application should be very clear in its language. It should clearly disclose the invention clearly and very in an elaborative manner, so that people can practice it in general. So for example, you presented a patent application and it has all the information, then by reading it, by merely reading it, anyone from that domain can practice it. He can actually practice it. This is recommended because the objective of patenting ecosystem is that not only the inventors get protection from for their invention, the progress of science and technology should also happen. So patents are granted so that inventors get secured, because there is always a threat that when you disclose your invention to a public domain, then anyone can got the idea and can copy it. But when the patent authority says that your invention is granted, a patent is granted for invention, you are secure. Then if someone copies it, then you can sue it for infringement. So this way they want to make a secure environment so that everyone who is doing any kind of research and development in technology, then it should disclose to the public. We should disclose to the public so that others can take motivation from it and can make more better products out of it, and this way the science and technology can progress. So this I mean, what happens when earlier, when patent system was not there, everyone doing this kind of research and development, they they keep the information secret with them. They do not want to disclose it because they were always worried about it getting copied, the invention getting copied. So they keep this entire information with them and they do not disclose it to others. So this way the progress of science and technology was not there prior to patent ecosystem. So patent ecosystem, the objective of patent ecosystem is that everyone doing research should get secured by the patent system, and they should disclose the information they have gathered during their R&D, so that others can take benefit from it, and then accordingly science and technology can progress, right? So draft in patent application requirement, the thing is that you are required to disclose each and every information related to your invention. Each and every information, by it I mean that the information should be such that anyone from that domain can practice the invention by reading the disclosure of the patent application. So after drafting, what happens, the application is filed by the to the patent office. It is submitted to the patent office. Then it, as I mentioned earlier also, it get published by the patent office. So generally a patent application get published only after 18 months from the patent application filing date. In these 18 years, the patent application is in hibernated state. Even you cannot access it. Whatever you have filed, you cannot access it. And only after 18 month publication happens. But you can expedite it. There is a provision of expediting publication process. So you can file an early publication request in Form 9 of with the patent office, and with a fee of 2,500, you can make your patent application published. So for example, maybe for marketing purposes, people do this early publication thing because they want others to they want others to know about their invention, that they have filed a patent application. So if you file a patent application and you wait for the 18 months, then obviously it is kind of delayed thing for corporate things. So when they file a patent application, they also file request for early publication, and their application get published within 1 month also. I mean, generally it takes less than 1 month, but in some cases it can get it also takes more than 1 month, but it is not more than 2 months. So generally in 1 month, patent application get published. You can enter your patent application number, you can give it to someone, and anyone can access it by going to Indian Patent Office website. So after publication, examination happens, but examination also doesn't happen organically. You have to file a request for examination. Once you file, there is a time limit for filing request for examination. Once you file a patent application, Then within 48 months from the patent application filing date, you have to submit a request for examination. Then only examination is taken up by the patent authorities. After examination, the patent office comes up with examination report or first examination report, which is called FER. FER in FER they give their opinion based on the prior art search, and then let you know whether they have any objection to the grant of the patent of your patent application. So if they have any objection, they write it there in the report, and then secure response to it. So once you receive the examination report, then we have to reply to it. Obviously, when they have objection, then we have to convince the examiner or the controller that the said objections are not true in nature, and there are so and so differences. Based on that, the objection should be waived. So when you file a patent response to this examination report, you register all your information that makes or that helps in getting those objections waived by the patent office. After this first examination report, and when you submit your report, your response to the FER, a second examination report may also come, but it is quite rare that second examination report come directly after first examination report. The patent office calls or schedule a hearing with inventor so that they can directly communicate and solve every conflict in relation to the patent application. So after this hearing, the final outcome is presented by the patent office. Obviously, it is related to either the patent application is accepted and it becomes a granted patent, or otherwise, in worst case, it got rejected, and there the life of the patent application ends by once the patent office says that it is rejected, then the patent application got got that there. So this is a very typical process followed by the patent office when you file a patent application till the grant of the patent application. So this is all I have to say for this moment for this particular session. Now I would like to invite you all to ask me anything about whatever I told you, or anything else you have in your mind in relation to patent related activities. Please go ahead.
Hello, sir. Hello.
Yeah.
Sir. Sir, we receive search report, sir. So based on that, we see in my report, sir, I have only one features in that, sir. And so what I have to do, sir, next, sir? Means so we have to reply to that.
Yeah, once you report, once you get the report, you obviously, as I mentioned, you have to go through each of the references, which I'm sure you have gone through it, and then accordingly, I would advise that you should not go by our opinion, because you being the inventor know ins and out of your invention, right? So entirely go through the prior art references that we cite in the report. Go through each one of them entirely, totally, comprehensively, so that you are aware what kind of information is being disclosed by that particular application. And if you believe that everything, every aspect of your invention is being presented or is there in that particular prior art, then obviously we cannot do anything. But in case you have any iota of doubt and iota of information that you can use to file a patent application, then definitely use it. Then, after this report, then obviously you have to go through the report, each of the prior art references that we share in the report, and then try to make a note of the differences, the novel, inventive, and non-obvious things, and then let us know that these are the things you believe could be used to file a patent application. Post that, we can assess that, and we can then create a patent application after that.
Okay, thanks, sir.
Welcome, sir. Yeah, anyone?
Anyone else, please, you can unmute.
Yeah, please. I mean, not only for the thing I've discussed, if you have anything related to patent, you can ask me anything.
Sir, my name is Anubendu Adhikari. I'm from chemistry department.
Sure, sir.
Is my voice audible?
Yeah,
Okay.
totally fine. Go ahead.
Sir, is there any different procedure, any extra document, or if I want to include foreign author or inventor in my patent?
I'm sorry, but I didn't get your question, sir.
So
Could you
if I
please
want
repeat?
if I want to include an employee from a foreign institution, so is there any like different rules or different documents you need, or just the usual one?
No, anyone, I mean, if you are fine, say for example, you are the true inventor and you want to include maybe your wife or your colleague as an inventor, you are totally free to do that. There is nothing extra that we need to do. You can, if you are fine being the inventor, you can add anyone else as the inventor of of your patent application.
So like I'd like to add collaborator from a foreign university. From their side, could any issues can come? It's like I would like to make sure that once we start the process,
that you need to confirm with the organization your said colleague is attached to. Then obviously there are directions or guidelines from different departments or different organization. So definitely, I mean, you from your organization also and other organization also, you should first check with the competent authority and then only proceed with that, because it may create conflict before. If you don't you don't follow the guidelines, then definitely you should first talk to the competent authority there and then take their permission, and then definitely you can do that. There is no additional thing we have to do. If they are fine, you are fine, then you can go ahead and make anyone as the collaborator or a co-inventor within your invention or patent application.
Okay, thank you, sir. So along this line, is there any, if I have any question, can you share your email ID or where I can contact later?
Yeah, definitely. I mean, you can contact Mr. Sudhar. He will redirect your questions to me.
All right. Thank you so much.
Pleasure.
Yeah, to add to whatever sir was saying, we are allowing for institutes from all the VIT sister institutes like VIT Chennai, VIT Bhopal, VIT Vellore, and also from IITs to add as collaborators of your invention. So this is the current rule that we are following. Maybe it will get updated in the future, but right now this is to clarify your doubt. So
will I not able to include anyone other from these universities?
No, sir, that's what.
Okay, so that means at this moment I cannot.
Yes.
Okay, all right. So thank you for the clarification.
If the institute is very good, I mean the foreign institute we are talking about, we can have a special request. You can request to the IAC, and we will forward that to VC sir, and maybe he can accept it. But Indian institutes, only IITs are allowed right now.
Okay, sir.
Hello.
Yeah.
Sir, after we issue the first, after we replying to search first report, sir, what is the next we getting, sir? What is next stage, sir?
So once you receive first examination report from
no search report. No, recently we received search report.
Okay.
After
So
the search report, sir.
yeah, after search report, you have to go through the prior art that are listed in that particular document or the search report, and then try to identify, because generally we identify that we opine that there are some features in that document which can be used to hamper the chances of getting a patent. So you have to analyze all the prior art references in that document and then accordingly see whether any difference exists, whether any inventive or non-obvious difference is there in your proposed invention and the prior art, and then based on that, on basis of it, you can then tell us that these are the features we want to move with the patent application.
Okay, sir. Thank you, sir.
Yes, sir.
Any other queries?
Hello, sir.
Yeah.
Sir, in the form of patent, there is features. What should fill in the feature? What is this feature we should fill it? I didn't get.
Yeah. So invention is a very broad and umbrella term, right? So every invention can be dissected into multiple features. So every inventive feature that you believe that it has the potential of creating an aspect which we can project in the patent application. So every feature which you believe could have the potential to get a patent, you should you should dissect your patent or your invention into multiple features, so that it gets easier to map it with the prior art. And the way I've shown you a table that we dissect a particular invention into multiple features. So for example, I would like to give you an example. There is a pen. You say, let's assume that you have created a pen or invented a pen. The pen can have a cap in it, a refill in it, which has the ink. It has a body, and it has any ornamental feature also, right? So these are 3 or 4 different features of your invention, your pen. So you want to assess every feature of it for novelty and inventive step, rather than assessing the entire product as a pen. You want to assess each and every feature of it, each and every potential feature of it. So you dissect it into multiple features and then accordingly assess it based on the prior art. So we perform a prior art search, and then based on the prior art search, we compare all these 3 or 4 different features and then see, and then tell you or opine you that feature 1, which is related to the cap, is being disclosed by this particular prior art. The feature number 2, which is related to body, is being disclosed by this and this prior art. So likewise, all the components of an invention could be categorized into multiple features, and those features then could be assessed in view of the prior art, and then accordingly a better patentability opinion could be given. This is what we believe, right? So these features are nothing but
Yes,
the
right.
different components of the invention.
Thank you
Got
so
it,
much,
sir?
sir. Thank you. Yeah, I got it. Thank you so much.
Sure. Thank you.
Thank
Sir, I have a question. First
Go
of
ahead,
all,
sir.
thanks for the nice presentation. For example, let us say if you miss the deadline for submitting the FER reply, can we request for any extension?
Yes, definitely. I mean, if you want to take extra time to reply to the examination, then you should file it. There is a form to be filed, and you can take additional 6 months, 3 months of time. So generally, what happens that the timeline to reply to FER is 6 months, but you can file Form 4 and you can take 3 months of additional time to reply to the FER. And also, I mean, even if that time period elapsed for some reason, then accordingly you can there are provisions to request for waiving of these. Say for example, by some reasons you could not apply, you could not respond to the FER, and it was deemed to be abandoned. Then you can request the controller that for so and so reasons I could not reply. So the controller he has the power to I mean, you can file a petition with the controller, and then accordingly, if in some case the controller believes that you should be given some sort of liberty or some sort of flexibility, then and in those cases also your application could be revived even if you forget about the deadlines or missed it for some reasons.
Okay, okay. Thank you, sir.
Hello, sir.
Yes, sir.
Sir, after replying to search report, sir, how much time required to publication, sir, for patent?
No. I mean, patent publication is a totally different thing in relation to our search report. The thing which we are doing, I mean, the VIT inventors and we at the Quran Purana, this is the kind of different activity before filing a patent application and publication of it. So once you give us, once we issue the patent search report or valid search report, there is nothing called publication. The publication happens only once you file a patent application. So as I told earlier also, I mean, once you apply for a patent and a patent application is filed, post 18 months of it, then publication happens. There is nothing called publication when you reply to our search report. After replying to our search report, you or your organization will request us to file a patent application. Then a patent application is filed. Then in case you are going by a normal or generic way, it will get published after 18 months. If in case you are going through expedited route, that is the early publication route, then this publication will happen after or within 1 month of your patent application filing. You should not confuse these two things, sir. Got it, sir?
Sir, one question from my side.
Sure, sir. Go ahead, sir.
Am I audible, sir?
Yeah, perfectly. Hello? Go ahead, sir.
Sir, what is the time time of expiry for a published patent and a granted patent?
Expiry of a patent, I mean, there is nothing called expiry of a published application. The expiry is when it is deemed to be withdrawn. This is the term used by the patent office, deemed to be withdrawn. So if you, for example, you file a patent application and it get published after 18 months because it is eventually going to happen. There is nothing we have to do to get it published. So after 18 months, it get published. So after this, we have to file a request for examination. So if a request for examination is not filed within 48 months from the patent application filing date, then it is deemed to be withdrawn. There is nothing called expiry of a non-granted patent application. It is deemed to be withdrawn. It is assumed that the inventors are no more interested in the patent application and they have withdrawn their application. So if you do not file your the request for examination, then it is deemed to be withdrawn. For the expiry of a granted patent, the timeline is 20 years from the patent application filing date. So if you file a patent application on 1st January of 2000, then your patent application is going to expire on 31st December of 2019. So 20 years is the timeline for a patent, a granted patent, from the patent application filing date, not the day of grant. It is calculated from the day it was first filed by the patent, by the inventors or the applicants.
Sir, one more question that like to be clarified. During the hearing of a patent, do we need to go there with the prototype? What happens there? I mean, like we have to go and present ourselves before the panel. What happens? Can you elaborate, sir?
Yeah. So during hearing, because what happens when they write something to you and you replied back in the form of text or emails or the response to your examination report. The thing is that there is chances of some gap between you and the examiners there in the patent office. So they invite you. I mean, prior to COVID era, they physically they ask you to physically come to the patent office website. But now after this thing, I mean, after Zoom and everything, or every hearing happens on Zoom or virtual meetings are there. So there is nothing mandatory to come with the prototype. They just wanted to discuss the findings of the examination or the search report. So they face to face or in direct communication want to discuss the things with the inventors. So they invite you for the meetings or these hearings, and then they they present their stand that this is how they think, and they want to listen to you, the inventors or the applicants. So this way a kind of direct communication can happen between, and the things can could be clarified in a more efficient manner. So that this is the reason of doing or happening of these hearings. There is nothing special is required. You just need to go there and present yourself. So even, I mean, in most cases, the inventors per se are not required to go and attend the hearings. Only the agents are required to go there and represent their client or their inventors.
Is it possible for online meeting also, sir?
Yeah. I mean, after COVID era or after this, during this COVID thing, everything is happening online only, and now everything, I mean, every hearing is happening online only.
Okay, thank you, sir. Any more queries from participants?
Sir, am I audible?
Yeah, go ahead, sir.
Sir, is it possible to claim a already published paper design part, sir? For example, I have been published a journal. So can I make a design patent, sir? Or it is already published, it is no more is possible to file a patent? Can you
Yeah,
clarify
so
that, sir?
this is a very good question you have asked. So say for example, by mistake you published a patent, your invention, and you make it public by publicizing it on a certain journal, then the patent office has come up with this thing. So a year's grace period is there for the inventors. So if you present your invention to a learned society or a scientific journal, for example, you presented your invention there, then within a time period of 1 year, you can file a patent application, and the patent, your earlier published journal will not be treated as a prior art for your invention. So the only concern happens when you make public your document or your invention, that the same thing, your invention, your publication could be cited as a prior art, that this thing is already in public domain. Then uh, there's no point protecting it by way of patent. So now we have a grace period of 1 year. So if you by mistake or by deliberately also, if you have make it public, you can then also file your patent application within 1 year of the publication. But beyond that, say for example, you have published the paper 2-3 years back, then in that case nothing could be done.
Thank you, sir. Thank you.
And also, I mean, for all the participants, I was asked to clarify on design and utility patents. So I would like to make a note or make a statement on this difference because we are getting queries from VIT that wherein you have asked us to file design applications or design application for design patents. So there is a difference between a utility patent and a design patent. So the general patent or the patent most of us are aware about are the utility patent. I mean, all patents that we generally go for are utility patents, and utility patents are for the functioning of an invention, right? And the design patents are related to aesthetics of a product, or a material or an object. So if you want to protect the looks or the aesthetics or the way something is perceived by the others, you want to protect that aspect, then you should file a design patent application. Otherwise, if you want to protect functioning or the working of your invention, then you should go for utility patent. Right. So I was told by Gautami, my colleague, that some inventors from VIT are sharing invention and ask her to file design application, but actually they are related to functioning of an invention. So ideally they should go for a utility patent, which is the general patent, not the design patent. Right. So for example, we received one invention with the title automatic lid opening soap box. So automatic lid opening soap box, I mean, one way it could be protected by a design patent, because the soap box obviously would have some sort of form factor or some sort of aesthetics which the inventors want to protect. But maybe the inventors are not aware that the functioning of the automatic lid opening soap box could also be protected. The way or by which means the automatic thing is happening, they can also protect it. So in such cases where there is a functioning embedded in an invention, then you should also consider going for utility patent. Right. So in case you just wanted to protect the looks of the invention or the object you are or the product you are trying to protect, then obviously you should go for design application, design patent. But in case if you believe that it has some sort of functioning by virtue of which it can be protected by utility patent, you should also consider and go for utility patent, sir.
Hello, sir.
Yes, sir. Go ahead.
Sir, I have one doubt, sir. So if you have one idea or invention, sir, so first we go for patent, then publication, or first we have publication, then patent? Not clear, so that's why I'm asking again.
Right, no issues. Though, so as I mentioned that once you file a patent application, then it get published by the patent office within after 18 months. So once, so for example, you file a patent application on 1st January 2022, then it will get published after 18 months. You have to wait for that much amount of time if you are not filing for an early publication. If you are filing early publication request, then it will get published within 1 month.
So after publication, patent publication, we can go for journal publication also, sir?
No, you can go for general publication by only filing this patent application. Publication has nothing to do with the publication. Sorry, with the other things. That is why we file a patent application. Even, I mean, patent application are of two kinds: provisional application and complete application. So in case you don't have entire information with you of your invention, then you can file a simple 1 or 2 page provisional application, and then you will have 12-month period to complete it, and then file a complete application. Once you file a patent application, be it provisional or a complete, you have the rights and the liberty to disclose your information related to your invention to others. You can make it public, you can publish it in general, or whatever you want to do, you can do it, because you have filed for a patent application. You have got the patent priority rights.
Okay, thank you, sir. My doubts are clear. So it is really nice.
Great, sir. Great.
Sir, can we file both, sir, like utility and design in one patent, or we have to play separately?
Yeah, I mean, because these are two different systems, patent, utility patent as well as design, you have to file two separate applications.
Okay. Is it possible for you, sir, like this is only for utility patent kind of approach? There is no chances of design patent part, sir?
Could you please elaborate your question?
Like this complete the explanation, the presentation at present is going on only for utility patent kind of thing.
Right.
Not the design part.
Yeah, in design, you only need to present the different looks or different, I mean, the images of the product that you want to protect through this design patent. We need different views of the product. So nothing in written needs to be submitted to the patent office also. Only the drawings or the images of the product needs to be submitted as a part of application, and nothing in written goes in the design patent.
Is there any patent like having both, sir, or only
No.
separately?
No.
Like
A utility patent only protects the functioning, because in
function.
utility patent you cannot protect what you disclose in the form of drawings. Drawings are not protected in utility patents. Only the functioning or whatever written in independent claims are protected. It can be made in the form of the figures you present, or it can have different looks or different aesthetics.
So is
Only
it
the
possible?
functioning.
Is it possible by your agents that design is also possible, sir? Can you make that to be happen?
Yeah. We provide every kind of protection. I mean, each and every IP protection, be it utility or design or copyrights or trademarks or anything. Anything related to IP could be protected by us.
Okay. That just now you told that like with AP students is only for utility, not for design, like you told. Is it reserved in that manner, or that depends upon the guides approaching you, or the MOUs between you?
No. I don't think there is something that holds you from filing both the application. If you want to protect your invention both by utility as well as design, you are free to go ahead and file for both the things.
Hello, sir.
Yes, sir.
Yeah, I have basically two doubt. One is means you have kindly said that we can even file an application for patent even after publishing an invention in a journal, right? So is this a new rule? I was not aware of this.
You are saying that there was some rule that stops someone from filing for a patent application if the same invention is published in some journal.
Yeah, I know that if something is published in a journal, then after that we cannot file a patent for that. Means
no. There is nothing like that. You are always free to file patent application. The only concern was that the same published thing or published journal can be cited by the patent office as a prior art, right? So now, if you can prove that the same article was published by you and you were the author of it, and you are filing for a patent application within 1 year, and in case objections are raised by the patent office, then patent office waive of these kind of objections.
Within 1 year, it will not create any problem.
Right.
And one more thing is like design patent. So as per my knowledge, we in India we cannot file patent for software, right? Only software we cannot file for it.
There are 7 or 8 areas where patents are not allowed.
Yes. So
And software is one of them.
yeah. So in that case, can we file patent for some aesthetics for software, not the code, but say for example some good design aesthetics of my website, for example. Can I
Right.
patent design file for that?
Yeah, definitely. If if you have a website, you can and you want to protect your UI or the UX of your web page, then you can file taking screenshot of different looks or different pages. You can file for design application.
Okay. Thank you, sir.
Okay, sir.
Okay, if no other doubts are there, we can close the session here. Right. So thank you so much, Lalit sir, for very patiently delivering the lecture in a very detailed manner and answering all of our queries
Pleasure, sir.
to the letter. Very nice presentation, sir. We really appreciate your effort today.
Pleasure, sir.
Yeah.
Thank you so much.
Can we,
Hmm.
sir, one request. Can you stop the sharing, sir? 1 second.
Sure. Just a minute.
We'll take a picture together. Request everyone to turn on their cameras.
I think sharing is already stopped by me.
Oh.
Right?
Okay, sir. I request others also to open their cameras. Yes. Okay. I needed to take a few photos for documentation. Okay. Thank you all. Thank you, participants, and thank you, Mr. Lalit. We'll end the session.
Thank you so much, sir. Thank you so much for initiating this kind of session. Really appreciate it. Thank you. Thank you, everyone.